of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today, we're talking about closing complex subject to transactions. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel and subscribe. You can find us on YouTube, Facebook, and X. On each of those platforms, you can find us at the handle @InRem Podcast. That is @InRem Podcast. You can also download an audio version of the show on Spotify, Apple, or other podcast platforms. Go there, leave us a review, a like. We'd really appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So for my legal update today, I'm going to talk about an issue that I see coming up over and over and over again with our investor clients, which is the need for an operating agreement for Wyoming or Delaware LLCs. So as our firm represents a lot of investors, a lot of these investors want to have anonymity. And so they go and they form LLCs in Wyoming or Delaware. They don't generally do it themselves. They pay some third-party service who assists them with it. And, then they think, okay, great. We have this Wyoming or Delaware LLC. We have anonymity. I've mentioned before on prior episodes that I'm not a huge fan or of anonymity. I think it does have its purpose for certain circumstances, but it's really not necessary for true asset protection. But nevertheless, a lot of our clients want to have that level of anonymity. So they go and they form these Wyoming and Delaware LLCs, and then they come to us to assist with real estate transactions, real estate closings. We help structure transactions, draft documents. We even assist in the closing process for certain transactions. And they, as part of the closing process, in order to draft certain documents, in order to make sure that we have the proper people signing documents and we're properly structuring the transaction, we ask for an operating agreement when we're dealing with a Wyoming or Delaware LLC. We say, okay, if there's a Wyoming or Delaware LLC anywhere in the structure, then we ask for that operating agreement. And so in getting that operating agreement, we've discovered, or asking for it, we've discovered one of three things exist. One, we receive a fully signed, executed operating agreement. It's like, okay, perfect, great job. You properly formed your Delaware or Wyoming LLC. That tends to be in the minority. Most of the time, we either receive a response, well, I don't have an operating agreement. I never did an operating agreement, never signed an operating agreement. Or second, we are sent a Word version of an operating agreement for the Wyoming or Delaware LLC. Well, it's a Word version. It's not even signed. And so we have to go back and say, did you not sign this? Where's the signed operating agreement? And, the clients come back and say, oh, well, I didn't know we needed one, et cetera. Well, you do. And it's critical. It's frankly, when you go and you form in Wyoming or Delaware, you're doing it for anonymity. You're doing it for what you consider to be better asset protection. Yet, if you don't have a signed operating agreement, it's actually the opposite effect. And let me explain. So in Arizona, when you form an LLC, because Arizona is not an anonymity state, you have to go and disclose to our corporation commission, which is the government agency that's responsible for overseeing the formation and operations of LLCs, corporations within Arizona. When you go and you file your articles of organization, you have to disclose who the members are and who the managers are. There's no anonymity in Arizona. And so you have to put that actually in those articles of organization, and they're, easily found, easily determined by, a title company, by anyone dealing or contracting with the LLC. It's all there for the public to see. And then in addition, we have statutes in Arizona. Our LLC Act states that if the members or the company does not put an operating agreement in place, that does not invalidate its existence. And instead, our statutes, our LLC Act, serves as the operating agreement. And it has provisions in there that you would find in a, operating agreement dealing with, profits and distributions and voting and meetings. It basically fills in the blanks of an operating agreement and can serve in the place of an operating agreement. So if you form an LLC in Arizona, there are certain circumstances where you should always have an operating agreement. But if it's just a single member LLC, you form in Arizona, you have a valid acting LLC even without an operating agreement. But that's not the case with Wyoming or Delaware. And the reason why Wyoming and Delaware are in anonymity states is because when you file paperwork, you file your articles of organization with the Secretary of State there in those states, you don't disclose who the members or managers are. You basically state that here's the name of the entity, here's our registered agent, here's the address, which is generally the registered agent's address, and that's it. And then it's signed by whoever's assisting with the formation or whoever's forming it. That's it. Like, there's no record publicly available as to who owns the company or who manages the company. It doesn't exist. That's why it's an anonymity state, because you can't go to Wyoming or Delaware and say, hey, show me, who's behind this LLC. They would say, I don't know. We don't have that. We never asked for that. It's not required. So because there's no public record of who owns the entity, the laws of those two states require that LLCs formed in those states must have an operating agreement, meaning for an LLC to validly exist and operate in Wyoming or Delaware, you must have an operating agreement, not a Word document of an operating agreement, an actual physical signed operating agreement in those states. So what do I mean by, well, you're actually losing your asset protection if you don't have an operating agreement? Well, if you are operating under the name of an entity that doesn't validly exist, then a creditor creditor of that entity can pierce the corporate veil because you're acting through an entity that has no legal standing. So if you're out there acting in the name of this Wyoming or Delaware LLC and engaging in business, and you end up, with creditors, you end up with, liability, they get to pierce the veil and come after you because the entity doesn't validly exist. It doesn't validly operate because it doesn't have an operating agreement. So the entity and you are now one and the same, which is the whole purpose of structuring an LLC and trying to structure your assets in such a way to create that corporate veil. Well, you're losing it if you don't have an operating agreement. So I say all that to say, if you're going to go out there and you're going to hire a third-party company, and, you sometimes, I hate to say, you kind of get what you pay for, they're going to do the bare minimum for you, and they're going to give you the operating agreement, and they're going to expect that you're going to figure out that it has to be signed, it has to be executed. they're not going to hold your hand. They're not going to send it to you by DocuSign. They're not going to take the steps to get you to sign it and say, hey, look, before we even form this, let's put an operating agreement. That's what we do on our Wyoming and Delaware LLCs. We don't form them until we have the signed operating agreement, because we don't want to risk the back end of the transaction where there isn't one because the client neglected to ever sign, but then goes out and starts operating in the name of the LLC. So we start first with the operating agreement. And then once the operating agreement's signed, then we go and we form the entity, because we know now that we've established its proper legal standing. So make sure that if you're using a third-party company to form these, that's not a law firm, and that's fine. You're going to save a few bucks, but you need to be prepared to do some of the heavy lifting, to take some of the steps you need to take to protect yourself. Otherwise, you're actually doing yourself a disservice. So it's very important to always, always have a signed operating agreement if you are forming an LLC in Wyoming or Delaware.
All right. Thank you, Sean, for the legal update. A few announcements to go over with the listeners. Every Tuesday following our show, we do the INREM podcast every Tuesday morning, but every Tuesday afternoon, we do the Creative Finance Collective. So what is the Creative Finance Collective? If you're new to that show or that experience, that is a grouping, a membership of professionals in the space of creative finance, mainly lawyers. We get together to talk all things creative finance. And the lawyers that appear on this appear from a variety of different jurisdictions, anywhere from Arizona, California, Colorado. We've had Ohio, Alabama, Georgia, Texas, from all over the place. We talk about what the laws look like in those states, what changes we're seeing, what the economic macro environment looks like. And mainly we're also there to answer questions. So this is your opportunity to engage with attorneys in the space of creative finance. And full disclosure, there's not a lot of them. And we've tried to bring them onto this to be here to answer your questions. So we're on for max an hour, but we're really on for as long as we get questions. So it's really vital for you, the listener, to be there and participate and engage and ask those questions. We like to get them. We know the lawyers like to get them, and it gives us a chance to discuss complex issues as it's facing lawyers in the space, but as it's facing investors as well. So make sure to be a part of that. 2 p.m. Arizona time, the collective. You can find it on YouTube, Facebook, and X. With that, if you have any questions on today's episode, make sure to post those in the chat. We're going to try to get to those in the final 15 minutes of the show. But if you're thinking about it now, or you think about it as we're addressing a question, then feel free to post that in the chat, and we'll address that, like I said, in the final 15 minutes of the show. All right. So we today are talking about complex or closing complex subject to transactions. Now, that might sound interesting in the sense that a subject to transaction, almost by definition, some might consider a complex transaction, but I guess, Sean, correct me if I'm wrong, we've been doing this long enough that there might be kind of a garden variety subject to transaction.
Yeah.
And then there might be ones that are fraught with a lot of difficulties that present problems of closing, right?
Yeah. And, and Eileen, can answer this as well, and maybe even better than I can. But for me, a garden variety subject to transaction would be, you have a conventional loan, no FHA, no VA. Let's just say I'm the buyer. I go and I enter into a contract. I say I'm going to take it subject to. There's never been any loan modifications, no partial claims, no anything. It's simply, you have a loan. I'm going to take it subject to. Maybe I'm going to pay you a little bit of cash at closing, and we close. There's no assignments. There's really nothing complicated. To me, that's a very basic garden variety. And frankly, that escrow is probably going to close or flow, similar to just a standard escrow transaction with maybe some different language in some of the documents and stuff. But for the most part, it's going to, go that way.
Yeah. So Sean mentioned it before. As a guest we have on the show, Eileen Brown. Eileen is having difficulties connecting to the show. So as she's able to log on, we'll bring her on. Hopefully she's able to join us here shortly and work through those technical difficulties. But Sean, as we work through this, let's lay the groundwork a little bit for what we mean, what we're doing when we talk about closing a transaction, because there's what we provide as lawyers, the documents necessary to transaction in the subject to space, but then there's what title companies and escrow agents are going to require to close a transaction. And so let's get into at least laying some of the groundwork for what it's going to take to close a subject to transaction from a documents perspective. So what should investor be thinking about as they enter the closing process? If they've used your forms, let's say, are they set purchase agreement and that's it?
Yes, assuming that they've been properly vetted and vetted for whatever state you're going to use any form in, whether it's forms that I've drafted, forms that any other attorney has drafted. You want to make sure that if you're using them in a state outside of the state in which they were intended to be used, that you're getting them reviewed.
Sure.
But just in general terms, you're going to want a purchase contract. It can be your standard purchase contract form. It can be the realtor form. In Texas, they have state forms. It could be a custom drafted attorney contract, but it's basically a purchase contract. And then you're going to want a subject to addendum, which can do multiple things. So the first thing that the subject to addendum would do is basically lay out all of the risks associated with the subject to nature of the transaction. And you're giving that generally to the seller because presumably you're working with a consumer seller. Now, if you have a consumer buyer, you're going to have disclosures that the consumer buyer needs to sign off on. Basically, what you're looking at in the transaction is you're analyzing, who is the less sophisticated, party to the transaction. Is it the seller? Is it a consumer seller who, is selling to an investor buyer who understands the ins and outs of the transaction? Or is it a investor seller who's selling to a consumer buyer who may not fully, understand the nature or risks of the transaction? So you're basically trying to make sure that all parties to the transaction fully understand and appreciate the nature of the transaction and the risks involved. The main risk, or two main risks for the seller is if the buyer doesn't pay, there's going to be damage to their credit. But if you're in a state that doesn't have anti-deficiency protection like Arizona, you could risk, potentially having a lawsuit or deficiency judgment against you. And then the second thing is the due on sale clause, that the lender comes out of the woodwork and says, hey, you sold it. I'm calling the whole loan due, and now I'm going to foreclose, on the property, which would once again damage credit and cause a potential deficiency judgment. From a buyer's perspective, if you have a consumer buyer, and to me, those are high leverage, high risk transactions dealing with the consumer buyer, because you have somebody who's coming who views the house as their home, right? I mean, it's one thing to invest in a property and be like, okay, this is an investment, I'm good with that. It's a different thing when somebody's buying it and they view it as their home. There's an emotional aspect of that. Not only emotional, but most people, when they're buying their home, they put down a sizable amount to close. And then on top of that, they put in other amounts post-closing to make it their own, right? They're not generally, if they're redoing the kitchen, they're not getting builder grade cabinets like the investor is putting in, right? They are putting in higher end cabinets. They're putting higher end countertops. They're putting in higher end flooring because it's their home. And so the risk is that they go and they do all this, and 2 months later, the lender comes out of the woodwork and is like, hey, I see, seller, you sold that. I'm calling the loan due. And now as a consumer buyer, you are scrambling around figuring out what you have to do. You either refinance, which you may or may not be able to do. You have to, maybe sell the property. Maybe you can work with the seller and restructure the transaction to meet the lender requirements. I don't know, but so you want to make sure that you're disclosing to that consumer buyer, hey, look, this loan is remaining in place. Just know that. And, if this lender decides that they're going to call the due on sale, then at that point, you need to be prepared. You need to know that you could end up with a loss. You could end up losing your home, and making sure that they're fully aware of that. So the subject to addendum does that. On top of that, and I addressed this in on top of that, you're going to want, go ahead, Andy.
I was going to say in the legal update.
Yeah, I addressed this in the legal update. If you're an investor buyer or even an investor seller, then in that case, you're going to want you're going to need to present generally an operating agreement. Now, if your LLC is in Arizona, the title company will take an affidavit of no operating agreement. Like I said, our statutes act as the operating agreement, so the title will accept that. But if you have a Wyoming or Delaware LLC, you have to present to title a signed operating agreement in order to close this transaction. I think Eileen might be up and running here, Andy.
Yeah, I see that she's up here, so we're just waiting for you to finish your thoughts. So I'm going to bring her up here. Eileen, welcome to the show. Thanks so much for being with us. Can you hear us okay?
I can hear you fine. Can you hear me?
Oh, yeah, loud and
Yay!
clear. Yeah, we got you. We're living in the world of technology, and sometimes it's awesome and sometimes it's not. Eileen, thanks so much for being with us. We want to tell our guests and introduce you to our listeners. So tell us a little bit about what you do. I know you're an escrow officer with American Title Service Agency. So give us your background, how you got into doing what you do.
Well, a very long time ago, 52 years, I decided I needed to get out of the cold of Nebraska and came down with my sister on vacation for a week, found a job, and flew back on Friday, packed my car on Saturday, drove down on Sunday, started work on Monday, and I went to work for a real estate company. I did that just for a short while. It was kind of a weird experience. And then I went into lending, got a job with a mortgage company, or a savings and loan actually, and was learning to process loans and close loans and all that kind of stuff. And I did that for 11 years. Then I switched over to escrow, the wonderful land of escrow, which I really, really love. It's just, there's so much more freedom and I don't know, just a better challenge. So you don't have to fit in the box to work. And so I'm kind of an outside of the box kind of person. So anyway, and I've been doing this. So a total experience in the industry is about 52 years. So that, of course, child labor laws weren't invented yet, but.
So, yeah, Eileen, I know you
the investor market and the subject twos and things like that, because it's, something that I've done for a long time.
So you bring up subject twos, and we're talking about the complexity of closing subject to transactions today. It sounds like you've had a bit of experience with subject to transactions. How did you get involved in doing those?
Well, in the late 80s, when the VA and FHA loans stopped being assumable by a simple assumption process, where it's just, filing a $75 fee at the last part of it, and the loan could be transferred without credit qualifying or anything else. When they changed that, and conventional loans were about that same time frame too, a little bit before then. They were, I think, 87 and 88 and 89 for FHA and VAs. We started doing the creative type things where we would do wraps or subject to transactions on those particular loans. Back then we even did FHAs. We don't anymore. So we started doing those in the very late 80s and early 90s. Again, interest rates, were fairly reasonable most of that time. So it was when the interest rates were very high, that became very popular to do the subject to and the wrap transactions because of the rates. We had government loans at 18 3/4 and conventional loans at 21% interest rates. It's like buying a house on a bad visa. so that's basically how we got involved in it, and it's been, you know, kind of just one of those little challenging things that, you know, I've been doing for a long time now.
Well, I like the story and I like the history behind that, because there's a common, I think, misconception, especially with investors who are just getting into this, or have followed a guru online and they've heard some new sexy term that's just referring to wraps or something else, and they think this is a new thing that we've come up with, that some folks have just come up with, and the professionals in the space have been doing these types of transactions for some time. That's the reality. Well, so as we brought you on, Sean and I were in the middle of kind of just talking about documents that investors need to consider or know about that are required, you know, typical subject to documents that are going to be required to close a subject to transaction. And Sean initially was discussing the purchase agreement, the subject to addendum, just getting into the operating agreement as well. But let me turn it over to you. And we've got a few to discuss, but from a title perspective, what would you identify as really the kind of the necessary core documents that an investor should be prepared and be aware of to close a subject to transaction?
Well, they need to have, of course, a really good, well-written contract that fully discloses everything and explains everything. And it has contact information for the buyer and the seller, addresses, phone numbers, email addresses, things like that. We need to have a copy of the current mortgage statement or statements if there's more than one loan that we're going to be taking subject to. In the transactions that include the solar loans, if it's an owned system, that needs to be part of the purchase price, the balance on that. It's a leased system is not part of the purchase price. So there's two different ways to look at that. The subject to addendums are very important because that's got all of the disclosures. Everybody's been explained thoroughly that this is going to have some issues for people and it just helps them understand, especially the sellers who are usually unsophisticated with these kinds of transactions, because they've not been exposed to them. And so that answers a lot of their questions and things like that. We almost always, I get a payoff statement from the underlying lender too, just to make sure that we don't have an issue with any deferred principal balances. If the loan was modified at any point in the past, there could be a deferred principal balance due on it and things like that. We don't want that to come up for our buyer clients, 3 years down the road when they go to sell that property, they find out they owe another $50,000. It's like, no, that's not a good idea. The operating agreement Sean has done a marvelous job of explaining the necessity for that operating agreement. We cannot be dealing with anonymous people in a real estate transaction. It just doesn't work. So anyway, we have to have those operating agreements, and they do need to be signed. And it's amazing how many of them I get that are not signed. Mm-hmm. And I have to send them back and say, you need to sign this before it's valid. So please do. And anyway, so we get a lot of that. But the current loan statement is usually has enough information on it that I can almost completely set it up. If they do have those deferred balances for modifications and things like that, then it's another discussion with all the parties. So that's pretty much it. Just, as long as I have contact information and all the copies of the data I need, I'm good.
So Eileen, I'm curious because one of the issues that I see on a regular basis, and you mentioned the consumer seller and making sure that the consumer seller is fully aware of this. One kind of area that I see that's not covered properly is the consumer buyer. Whether that consumer buyer is the actual party to the subject to transaction, or contract as the buyer, or, they're an end buyer on a chain of assignments,
Mhm.
where I don't see a lot of times that consumer buyer is getting what I believe are the proper disclosures as to the nature of the transaction, the risks involved. Are you seeing that as well on your end?
I do see that on occasion. When you do an assignment, you're supposed to give the assignee a copy of all of the previous documents, including the initial purchase contract and including any additional assignments that were between yours and his. It's amazing, though, that a lot of times I see that people do not provide that documentation. So when I get an assignment, one of the things that I do right away is send a copy of that original contract and any other assignments that I've already gotten. Sometimes I get assignments that I don't even have connected the dots to the previous assignment. And it's like, I can't deal with you until you provide me all of the assignments in between, and I know you have all of your documentation. So, yeah, anyway, that's kind of, it definitely is an issue. I find that most of our buyer contacts are a little more sophisticated and knowledgeable about the subject to world, but not all of them. Some of
Right.
them, this is their first transaction. And so it takes a lot of education and, patient conversations with them to make sure that they understand what their duties and obligations are and what the caveats are for those
Right.
transactions.
Yeah, exactly. So you also mentioned when you're seeking the loan payoff that you're looking for modifications, for forbearances, those types of things. And if you come across them, you have a follow-up conversation with the parties.
Yeah.
One of the new things since COVID is the whole partial claims mortgages.
Yes.
How are you guys dealing with those? I see them as kind of muddying up the transaction a little
They
bit.
definitely muddy up the transaction.
Yeah.
Definitely do. And most of the partial claims that we see are actually involved in FHA loans, which we can't do. That's a corporate policy.
Right.
So, but the partial claims, if there's a partial claim on it, it needs to be paid.
Yeah.
And not taken subject to. The same with any down payment assistance loans, that type of thing. Those down payment assistance loans are written very, very strictly, that it says that that upon the borrower vacating the property, even if they're just moving out and renting the property out, that note is due and payable at that point in time. So those are things, that we just can't wrap those,
Right.
whether it's in a conventional loan, which they do have down payment assistance loans on conventional loans as well. But those are just ones that we don't we don't handle those as subject tos.
Right. So we talked about some of the documents on the front end of the transaction just to get the escrow opened. What are the documents that the parties will be signing on the back end? Like, is there a wrap note, mortgage? How does that play out?
Yeah, on the conventional loans, we use a performance note and deed of trust, which basically says that if the buyer is unable to perform under the obligation to pay that loan that they're taking subject to, the seller then has recourse to be able to foreclose on that property. He could foreclose on it if the underlying lender calls the loan due and payable, or if they're delinquent. Okay. And on the VAs, we like to use, in fact, it's again, corporate policy at this point in time, that because the Veterans Administration does not consider an agreement for sale a disposition of the real property, we use the agreement for sale because then insurance can be handled more easily. We can add the buyer to the existing insurance. It does not create any red flags. The agreement for sale, the underwriting guidelines say that it's not due on sale for that type of transaction with that, using that agreement for sale. There are some of my clients that like to use the agreement for sale even on a conventional loan because of that same, it's arguable that it's not a disposition of the property because the seller retains fee title. And so it makes it a little easier on those. So that's our stand on that. And then after closing, thank God for transaction coordinators, because we don't prepare certain documents for after closings. Things like a power of attorney to allow the buyer to get information from the underlying lender, power to work with the insurance company, the seller's insurance company. That's kind of an iffy thing too, because I don't know of any insurance company that will honor a claim once the seller has deeded out of the property. But so I always counsel my buyers, get your own insurance policy. You're going to pay for the seller's policy too, but it's not going to make any claims payments. So get your own policy because you want your coverage. Let's see what else. And they have, they've got a whole bunch of documents.
Now,
there's an assignment of insurance proceeds,
right, assignment of insurance proceeds, and
authorization to.
And please, if you are purchasing these subject twos, use a transaction coordinator. It's so worth it, because these are documents that I don't have access to, and so I can't prepare them for you.
So Eileen, what documents? I know that in just a garden variety conventional transaction, whatever that might mean anymore, but, your standard one, there are documents that a title agency will prepare to close the transaction. What documents in a subject to transaction will American Title prepare?
We will prepare the servicing agreement for the account servicing. We'll prepare the note and deed of trust or the agreement for sale. We also prepare and have signed some disclosures about the due on sale actions and things like that. And then all of our standard normal, if it was a cash transaction type thing, all of our little disclosures that we have to have signed, and little affidavits, and that kind of thing, deeds.
I want to go back to the agreement for sale for a minute, because I actually really like agreements for sale. I think they're a good vehicle. I think that lenders don't see them as negatively as an actual conveyance of title. Not to say that, it doesn't fall within a due on sale clause, because, at least on conventional loans, Fannie Mae, Freddie Mac, it would technically, but but I still see where my clients say, well, it's a VA. And I say, well, do an agreement for sale, go see Eileen. And they say, no, I still want to do it conventional. And so what do you see as far as like the negatives of an agreement for sale as opposed to, say, a traditional wrap note and deed of trust?
Well, with the agreement for sale, I have a lot of my clients say that they don't think that they can get the IRS deductions for the interest that's paid and the taxes that are paid on the property, which I've used these myself. I've bought and sold houses on agreements for sale for many years. And I got audited one year and I had an agreement for sale recorded on a piece of property. And when they audited me, they said, you can deduct the interest because you have this recorded agreement. And so that's, to me, is just not a really valid argument not to use an agreement for sale. We do occasionally find a lender that does not want to handle a loan for either a refinance or for the resale of the property to a consumer where there's not fee title ownership by the seller. I see that once in a while. Wells Fargo is a big one that does that. They will not process a loan for a person who's buying a property from someone who has equitable interest in it, which is just bizarre, but that's their underwriting platform. So and there's probably a couple of others, but I know Wells Fargo is the big one. So it's sometimes they have to go find a different lender rather than one that's using Wells Fargo's platform to be able to do their refinance or their sale and purchase. I have had occasionally when we had an agreement for sale that a borrower or owner that wanted to do a refinance, and we converted it to a note and deed of trust, recorded the payoff deed. Now it's in their name, and it's a consummation of that agreement. So we don't have to wait the 6 month seasoning and that type of thing. So have had that be able to be used in that particular scenario. But that's the biggest issue with using the agreement for sale, and it's very surmountable. You just you just shop the lenders. And so you find one that will not be intimidated or confused by using an agreement for sale ownership.
Yeah, and you use the word ownership because I think there's a misconception out there that you are not really the owner. You are the owner for all purposes. The only difference is that instead of the seller having a security in the property by a lien created by a deed of trust or mortgage, their security is holding title. So it's almost like when you buy a car and you leave your title with the lender.
Right.
It's the same concept for real estate. You own it. You have all rights with respect to that property, everything, but the seller's just holding title back as security for the repayment of the loan.
Yep.
Yeah.
That is absolutely
Very interesting.
So Eileen, talk to us about, we've talked about documents. I want to get into mistakes that investors make, because that's just fun to talk about. But what are the common mistakes that you see investors make that delay closing on subject to transactions?
mostly just not getting their ducks in a row before they come and see me. They don't provide adequate time for us to be able to do our job, especially when we have assignments and multiple assignments. If we have an HOA, we can't order that HOA statement until we have that final buyer. So if you don't tell me that you're going to be assigning this, I may go ahead and order an HOA, which is going to then add an additional expense to the transaction because of the fact that I have a statement and now I've got to get a new statement because we have a new buyer. And so then these HOAs do charge for previous statements, most of them. A lot of times on the subject to transactions too, they don't even put any information that there is a homeowners association involved with that property. Now, I usually look it up if it's not if it's one of the investor contracts and it doesn't mention a homeowners association. I will look it up and see if there is one of record, and I can do that search by the Corporation Commission, put in the subdivision name, and 90% of the time I can find out who the association is managed by. There are some smaller associations that I don't have that ability to do because they don't have to have registration with the state. So basically just information. And also some of the things that I see that Arizona has House Bill 2747, which requires investors who are going to be assigning their transactions or flipping them, that they have to disclose that to the seller. And if they don't, the seller can unilaterally cancel the transaction if they find out about it. And so that's one of the things that I see is missing a lot when they're doing these kind of transactions and they do want to assign, is that they fail to make that disclosure to the seller.
Have you had circumstances where the seller has used that to cancel? And
yes, I have.
Oh,
I have one right now. And not only did they use that to cancel, about 2 days after the contract was expired and he accepted it and he had canceled the contract and it was ready to expire, that first buyer recorded a memorandum of interest clouding the title. Oh yeah. And so once they record a memorandum of interest, and even though he properly canceled it using the HB 2747, we cannot title insure it because of the fact that just because we know we're right, we would still have to defend our actions in court if this previous buyer pitched a fit and just for a nuisance, and he might have been just able to be a nuisance. It would cost us probably at least $10,000 just to defend our position. So we can't just take that as a carte blanche. Yeah, we don't have to address it. So we have to get a hold of these people and get them to terminate that memorandum and be able to record that termination. Luckily on this one, it has been signed. I don't have the original yet, but hopefully I'll be getting that today or tomorrow.
Well, public service announcement. If a seller properly cancels the transaction, even if it's because of a lack of, proper disclosure regarding assignments or wholesaling, you cannot record a memorandum. That technically is a crime, number one. And number two, The minute you do that, it subjects you to $5,000 in statutory damages or triple the actual damages, whichever is greater, plus attorney's fees, plus costs. It's a significant thing. So don't do that. That's just, frankly, it's unethical. It's illegal. And, if you messed up, accept the fact that you didn't put that disclosure in your contract, go see, an attorney or somebody who can, give you the right language and information on how to do it better in the future and move on, but don't go and wrongfully cloud title. That's one of those things that I think just when people do that, it just gives investors and folks working in this space just kind of a bad name,
It does.
Yeah.
It does. And I think it started from them trying to protect themselves because sellers are unsophisticated and they don't understand that when they have a contract with somebody, it's a contract with that person and they can't go out and accept a contract from another person, but they do because there are unethical investors out there that will say, oh, I'll give you 5,000 more than that guy, sign with me. And it's like, he's already under contract. It's like, why would you do something like that? And so I think that they started doing those things to kind of protect their interest. And I don't know, probably on some webinar or seminar somewhere that somebody from someplace else told them they could do that, that it would be a good idea to protect their interest in that contract. But that really doesn't happen all that often. And no, but I think that's where it originated from is those kind of situations.
Yeah. And on traditional sales, nobody ever records memorandums.
No,
it's only when you have these investors. Yeah.
No, it's only the investor world that thinks that this is a good idea.
And there is a time and place for it. Don't get me wrong. If you do it right, it's fine. But if you don't have a valid contract anymore, don't go and record a memorandum. Or if you have previously recorded it and it's properly canceled, you need to release it.
Right.
So we've slowly, just almost by accident, but maybe it was planned, we've slowly gotten into the more complex transactions from just your garden variety subject to transactions. So I want to identify a few more of those and talk through what you have to do to work through the problems presented in that. But investors, they like good deals. They like good opportunities. And oftentimes that means they're finding properties that are distressed. One common scenario can be a property that has a pending foreclosure on it. So what are the tasks that need to be accomplished to close a subject to transaction with a pending foreclosure?
Well, you have to be able to get a reinstatement statement from either the lender or the trustee, depending on how their relationship works. I try to get it through the trustee as often as possible because they're a little easier to work with. But that does require a written authorization from the seller authorizing me to get reinstatement figures. And if we're too close to that foreclosure, that trustee sale date, it's very, very difficult to do that. What I usually suggest if we're, 2 weeks or less away from a trustee sale, have the seller request an extension or a postponement of that sale for 30 days to allow us to be able to get that documentation. So that's real important. So that's the biggest thing with the trustee sale. And it also then does also open up a little bit of possibility of a lender discovering that we're doing a transaction that has a subject to on it. And again, making that due on sale possibility a little bit greater. And, I have done thousands of these and I've only had one called due on sale. So I try to be as careful as I can.
So speaking of the due on sale, so if you reinstate, obviously the money's coming from a title agency over to the lender.
Right.
Presumably the lender might look at that and say, well, the property sold, but yeah, we didn't get paid off.
Right.
But you haven't really seen that occurring.
Not very often. It does sometimes with the smaller banks or lenders. That would be more likely to be an issue than if it's, a Wells Fargo or a Bank of America or I don't know, Shell Point, Resware, all of those. It's the major big lenders. they don't notice those things as much because of the fact
Mm-hmm.
that they have so much volume that it's not as likely to get noticed. The smaller banks, yeah. I had
Mm-hmm.
one of my clients did a transaction through another company that did a subject to with a Johnson Bank. Johnson Bank is a very small bank. They pay attention to their customers, and it got called due and payable. And so they had
Yeah.
to undo the transaction and then did a lease option with the seller. And so that was a little difficult. They were not very happy about that. And I said, well, even if I had done it, probably Johnson Bank would have found out anyway.
Right. Yeah,
It wouldn't have been
exactly.
any different. But yeah, so that does happen. But and if the bank calls us and says what's going on, we're going to have to tell them. We cannot lie about it. We just are
Right.
not going to do that. That's not part of what we're allowed to do. And so
Exactly.
this is what we're doing. The seller's in distress. We've got somebody who's willing to bring it current and take over the payments without going through the formal assumption process. And the formal assumption process, really, on a VA loan, you have to be an owner occupant. You can't do it as an investor. It's just not possible. So on a conventional, if it's not an adjustable rate loan and the adjustable rate features, you're never going to get a qualified assumption anyway, because they just don't do them.
What about FHA? Is that the same rule? That you have to
FHA,
be
they could
owner
do a
occupant?
qualified assumption, but again, it's an owner occupant only. So it's
Okay.
not for the investor world. And the reason that we don't do title insurance and escrows on FHA transactions is because the FHA does have the authority to sanction everybody in the transaction. And a lot of people don't realize what that is, but I have had personal experience with a company that did that. They had an agent. It was a small real estate company. They had about 35 agents. They had one that did exactly this type of thing. And FHA sanctioned the whole company. All 35 agents could not for a year deal with a buyer that was getting an FHA loan or with a seller that had an FHA loan to pay off. And the broker had to pay a hefty penalty, a fine. And so because of that, and FHA loans in Maricopa County, at least, are about 14% of our marketplace, it's not worth the risk for us to take that option to go ahead and help with FHA wraps or subject twos. So that's why we don't do them.
What about subject to transactions with a seller carryback, where the seller's carrying back a portion of the equity? Does that present any complex problems to closing?
It's just a matter of doing a more complex note or agreement for sale. It's really not a difficult thing, and they can be done, with the exact wrap or the subject to on the first loan, and then a separate note for the seller's additional equity, or it can be an all-inclusive where, okay, let's say the seller has a 2.75% loan and it's $200,000 balance. It's a $500,000 sales price and the buyer's only got $100,000 to put down. Well, it can be combined in that for that $400,000 at, say, a 4%. And then the seller gets the benefit of the uptick in the difference on his underlying $100,000 loan or $200,000 loan and the total loan amount. So there's a lot of different ways to proceed with that. Or it can be, we take the first one over at the 2.75%, and then we do a new loan to you for whatever interest rate or terms that you agree on. I've even had them where they take principal only payments on the seller's equity.
Mm-hmm.
And, IRS can impute interest on that, which would be a penalty to the seller. So that's kind of like, a little less comfortable than I would like it to be. But, so that's something to be aware of.
The seller would have to pay that,
The
right?
seller.
It's
The
a
seller
tax
is
to the
going to be
seller.
imputed that, okay, you should have been charging market rate interest rate. That's at 6% now. So you're going to pay us income tax based on the fact that you should have been receiving 6% interest. So it's like, oh, ouch.
Yeah, that's it. But as far as the title company goes, you guys aren't giving tax advice.
Oh,
That's
no,
really up to the
absolutely
seller.
not. We don't even bring it up.
Right. Yeah.
It's like,
You guys, okay,
talk
we'll
to your
close
tax
it.
accountant.
Yeah.
Yeah.
Interesting.
Yeah. So
What about these transactions with just a long list of assignments that come in? You know, the whole daisy chain of assignments, 3,
Uh,
4 of them. What kind
yeah.
of problems does that present to close?
Well, it makes it a little more difficult just to keep everything straight in a file because you've got all these different players and you don't want to cross the lines with everybody. You don't want to, I don't like to do just a mass email, include everybody on it because then most of my people that do the assignments don't want their information or their clients' information shared with the other investors in the chain. So we have to be careful about that. And then again, you know, it gets to the point where if it's too awfully lucrative at one of those steps, that it's uncomfortable for me to handle a transaction where the seller's getting, you know, $50,000 and the investor's getting 75. That's to me not very ethical, and I have a hard time handling those kind of transactions. But it also depends on the sales price. If it's it's $1 million house, it's like 75,000. It's not that bad. So it's not that big a deal. But you know, when we've got a $200,000 transaction and somebody's making a lot of money on it, that's uncomfortable for me, and I can choose not to do it. Escrow agents have the right not to handle a transaction. We don't have to handle one just because somebody wants us to. So we can just resign and say, no, we're not going to do that. So.
Well, Eileen, thanks so much for being with us. We appreciate it. We could really spend multiple parts and multiple episodes on problems with closing. So we appreciate you taking the time. Tell our listeners where they can find you and how they can connect with you online.
Well, I don't even have social media. I'm too old. It's just terrible. But my email address is ebrown@atsAAZ.com. And my phone number is 602-424-7222. You can reach me there pretty much about 12 hours a day. So.
All right. Well, Eileen, thanks so much for being with us. We really appreciate it. And I look forward to doing it with you again.
Okay. Well, thank you very much, guys.
All right.
Appreciate
you. Good day.
Hey,
all right.
Andy, before we go,
Sure.
We there were some questions and we neglected to get to them, and that's what happens with it's okay. We'll do them on the collective today. So I just wanted to make that announcement that our producer wasn't able to be with us today, Mayu, who normally grabs the questions and posts them and all of that stuff. So Andy and I, we neglected to track down the questions, but we will be on the collective tonight at 2:00 Arizona time, 4:00 Central. So, we'll take down these questions and we'll make sure to answer them the first part of the show. So tune in for the collective.
All right. With that, everybody, thanks so much. Join us next week, and then join us at 2 p.m. today for the collective. We'll see you next week.
Have a good day, everyone.